This is attorney Ted Bond Jr. I practice law here in Lake County, Illinois, and a primary part of our practice is representation of landlords in eviction cases. One of the most common questions that we receive is how long does it take to get a tenant out of the property after they stop paying rent? The answer to that question is on average about 6 weeks. Although sometimes things will go a little faster than that, and sometimes they will be a little slower depending on the circumstances of the case. The general procedure is that after the tenant stops paying rent, you are required to give them a 5-day notice. We recommend that all our clients personally serve that notice upon the tenant so that there can be no dispute as to whether they received the statutory notice. In some cases, the clients are unwilling to do that themselves, and we can retain a process server to serve that 5-day notice. The notice will inform the tenant that they must pay the entire balance due under the lease within those 5 days, and if they fail to do so, an eviction lawsuit will be filed. So you have to wait the 5 days, and at that point, a lawsuit known as a complaint enforceable entry and detainer can be filed. Our firm uses electronic filing of those cases. So in Lake County, we're able to get those cases typically filed on day number 6, so very quickly after the 5th day if the tenant does not pay. Once the case is filed, a summons is issued and an initial court date is assigned, typically about 10 days to 2 weeks out after the case is filed. And we give a summons to the process server and ask them to try to get the tenant served on the case. At the initial court date, we will appear on the landlord's behalf and advise the judge whether or not the summons has been served. If it's not been served, a new summons is issued and a new court date is assigned. If the summons has been served, a determination has to be made as to whether the tenant is going to contest the case. If the tenant does not appear in court, which is somewhat common, a court order is going to be signed immediately telling the tenant to vacate the premises. If they do contest the case, a trial date is typically set about 7 to 10 days after the preliminary court date, and we then need the landlord to appear to give testimony at a hearing in front of a judge. At some point, a court order is going to be signed telling the tenant to leave the premises by a specific date. Once we obtain that court order telling them to leave, we take that court order and place it with the sheriff's office for the physical eviction of the premises. Here in Lake County, the sheriff's office typically has a bit of a backload, and you cannot get an eviction date scheduled until about 2 to 3 weeks after the court order telling the tenant to leave the premises has been signed. So in many cases, a judge may order a tenant to leave within, say, 7 to 14 days, but we're not able to schedule the sheriff to be out there until a little bit of time after the court order directs the tenant to leave. On the date that the sheriff is going to be there, most tenants will vacate the premises voluntarily as they don't want to be physically removed from the property. But if they do not do so, the tenant will see the sheriff on the date assigned. The landlord needs to be at the premises to assist with changing the locks and removing the belongings, and the physical eviction of the premises is completed. So again, depending on how smoothly things go with service of the tenant and whether or not the tenant elects to contest the case, the process is going to take on average 6 weeks. It will sometimes take a little bit longer, and occasionally, if things go very smoothly, a little bit less than that. If you have any questions about the eviction process, please feel free to call us. We can be reached here at 847-599-9101. And again, my name is Ted Bond Jr. Thank you for listening to our video.